Okay, let's see here. So I see that the panelists are on the line, Hillary, Rebecca, and Sarah. So we're going to get going here. We are excited and thank you for the slight intermission that we had. We went much faster than we expected. But for the pro bono training then, we were just celebrating with Representative Gongershowitz and Senator Castro, and now we will launch into our pro bono training. There is CLE available for this training, so if you are in Illinois, a licensed attorney in Illinois, and did not register your ARDC number, please make sure to get that to me within like the next day or so, okay? This is a recorded training. We will post it on our website. But I need to make sure that I have your ARDC number to register your CLE credits. Also, before we get started, I wanted to point out a number of handouts that you can find attached here to the presentation. You'll see the agenda, you'll see the PowerPoint slides for which you can take notes from. You'll also see a one-pager developed by Hillary Richardson and our internal staff at NIJC. So it explains what this extension of the law means, built upon the law that was passed in 2019 and based in federal legislation. So please check that out. And then also, last but not least, we hope you're attending today because you are interested in helping out one of the young folks that we're trying to represent. You'll find a case list attached here with 8 cases on them. 4 or 5 of them are urgent cases. Hillary's going to explain a little bit more about that, but we invite you to check out that case list as well. So for today's training then, Hillary and Sarah Gadiri of Chapman and Cutler, as well as Rebecca from CLS, will be giving us an overview of SIJS. They'll be talking about the implications of this extension of the law. Sarah will lead us in a great discussion of what pro bono attorneys can do based on her experiences. And then we'll also be talking about the current needs for SIJS in Illinois and the various counties for which we're looking for counsel. Okay, we will have time at the end for a Q&A. And please, if you have questions or comments along the way, drop them in the chat. It's a much more lively discussion in these virtual platforms when we see your questions and comments. For those of you that have not joined us before, just a brief overview of what is the NIJC and what do we do. We are part of the Heartland Alliance based in Chicago, Illinois. The National Immigrant Justice Center, or NIJC, we have 5 offices across the country, 2 in Indiana, 1 in DC. Our policy team is based in DC, and then we have a lively office also in San Diego, California, there along the border. We combine national and local advocacy and education with federal impact litigation and direct legal services for a combined impact, telling the client stories, telling the experiences, sharing the experiences of our legal advocates to push for a more humane and just immigration system. Last year, we served over 9,000 non-citizen clients, and this is only possible with our fabulous network of over 2,000 pro bono volunteers. So we're so grateful, and we know that none of this is done without the village that surrounds us, and so we're grateful for that village and all that we can do together. As I mentioned, we have a great panel of attorneys today that are talking to us about this issue. Their contact information is here as well. I will put my contact information at the end if you didn't send me your ARDC number or have questions about general engagement or CLEs with NIJC. So with that then, I am going to turn it over to Hillary and Rebecca to get us started, and thank you again.
Hi everyone, welcome back to the training portion of our event. To echo Ellen, I'm really excited about the event, the opportunity to talk about this extension in protection, and I'm going to, at the outset and at the end, just really encourage folks to look at our case list of pro bono cases, because we do still have an urgent need for pro bono attorneys to help these vulnerable youth and children, and that is throughout the state of Illinois. So we do have some cases in Cook County, but we have some that are outside of Cook County, and those are our most urgent needs right now. So please take a look at that case list. We'll be plugging it kind of throughout the training, but we do have extensive training materials, as you'll see here. And as you'll see, as you may have seen, if you've been a pro bono attorney with us, we hold your hand every step of the way. We do our very best to make sure you are as supported as possible. And Sarah can talk more about what it is like to be a pro bono attorney with NIJC on this particular topic. So with that, let's jump right in. We're going to start with a brief overview of what SIJS is. And we're going to do this briefly because most of what I imagine you want to hear at this point is about that extension, but just to kind of quickly review what the initial federal relief is. So Special Immigrant Juvenile Status is a federal form of immigration relief. It's available to kids who've been abused, neglected, or abandoned by one or both of their parents. And it's a form of relief they can apply for once they're here. It's not something that you can apply for in your home country and then come. It's for kids who are already here, sort of regardless of their status, if they've suffered that harm from a parent. It is really important for kids in these vulnerable positions because it leads to protection from deportation. It leads to, there is a long path, which we'll talk about, but it does eventually lead to a green card, lawful permanent residency, and eventually citizenship, which is a level of stability that's really important for these kids who have experienced trauma and have a lot of other things going on in their lives that they need to worry about and heal from. So this is just removing one barrier for those kids. If we could go to the next slide. So the statutory requirements under immigration law are that the child be under 21 years of age and unmarried. As I said, they have to be present in the United States. And then this is the piece that we're talking about that's specific to Illinois. So the federal law delegates these specific findings regarding the child's abuse, abandonment, or neglect in their best interest to a state juvenile court. So a state juvenile court has to have either declared the child dependent or made a custody determination. The state juvenile court is the one with the expertise in child welfare and in best interest. So they have to find that reunification with one or both parents is not viable due to abuse or neglect or abandonment. And they have to determine that it's not in the child's best interest to return to their home country. This is the piece that we're talking about today that's going to make the biggest difference for these kids, because if the child doesn't have access to a state court to make these best interest findings, they're not going to be able to apply for federal immigration relief. So the state courts here, the juvenile courts, really are the gatekeepers for these children to then be able to access the immigration benefits for which they may be eligible. The final statutory requirement says the Secretary of Homeland Security consents to the grant of SIJS. That just means that they submit their application and it's approved. That last step, typically the immigration attorneys, or NIJC in our case, submit. It's a pretty straightforward form. The big piece that we'll be talking about, as I've said, is this juvenile court piece, which is the predicate order necessary for the child to then apply. And if we could move to the next slide, there we go. So it's a three-step process. This is how I try to describe it both to my clients and to pro bono attorneys. So we have an idea of kind of how long we're looking at and what the steps are. So the first step is that predicate order entered by the state juvenile court. Once that order is obtained, and only once that order is obtained, can the child work with their immigration attorney to apply for the actual special immigrant juvenile status. Sometimes known as a special immigrant juvenile visa. That piece is really important. That is the immigration authorities, USCIS, saying that they believe that the child in fact qualifies, that they meet all of the statutory requirements. That approval, in my experience, is typically straightforward if we've gotten an appropriate predicate order. However, for many children, especially those who are coming to us from the Northern Triangle of Central America, they then have to wait a period of 3 to 5 years before they are actually able to apply for lawful permanent residency. And lawful permanent residency, the green card, is the thing that actually provides them that protection from deportation, the ability to work lawfully, puts them on a path to citizenship. So that second piece, applying for and being approved for actual SIJS, is, while it is an important step, it's a key step, it doesn't actually provide the final lawful protection. So I think the important thing to keep in mind is that it is a long path filled with a lot of uncertainties. But once we are able to get that state court predicate order, the children then are able to get into this sometimes very long line to finally get to the end of the road, apply for their green card, be approved, and be on that path to citizenship. So going back quickly, since we'll be talking about these predicate orders and the authority of state courts, particularly in Illinois, where we are looking for state court authority is actually not in the INA, the immigration statute, but in the accompanying regulations. So if you remember in the INA, it states that a juvenile court has to make certain determinations. The juvenile court means any court in the United States that has jurisdiction to make judicial determinations about the custody and care of juveniles. In Illinois, basically what that means is any court that has anything to do with kids or with custody or child welfare. So that means divorce court, parentage, guardianship, adoption, juvenile dependency. It also, and we haven't talked about this a ton, it also includes juvenile delinquency cases because that court is also making determinations about juveniles, and they also, depending on what the specific requirements of the case are, maybe placing that child under the state's custody. So those are the courts that have this authority that are acting as juvenile courts. What we're going to be talking about today is the fact that many of those juvenile courts in most states, the age of majority is 18. And what that means is if a child is not able to access a state court to get these findings before they turn 18, then even though under federal law they're able to apply for SIJS, they actually can't get that predicate order over the age of 18, between the ages of 18 to 21. And so effectively they're kept from applying for that release. So I'm going to turn it over to Rebecca to talk a little bit about what that state court process looks like. And we'll go into that in a bit more detail later as well, but just so you have an idea of what it looks like in that state court.
Let's see, we can't hear you, Rebecca. Oops. It shows that you're not muted. Sorry about this.
I think what we can do, because Rebecca will be also talking to us a bit later in the presentation, if we can get you, oh, was that it?
I don't know. Can you hear me now?
Yep. Yeah, we can.
Good. I just, I wasn't muted. I just unplugged my camera and plugged it back in. But can you see me? Because I'm frozen now, right?
You're frozen. That's true.
All right. You hold on. Give me just 1 second, okay?
Sounds good.
Can you hear me?
Yes, we can hear you.
All right. I don't know why this is happening. This has never happened to me before. I'm going to turn off my video.
Sure.
Okay, because I seem to be frozen. And I'm just going to talk, but you can still hear me?
Yes,
Okay.
we can. Thanks.
All right. For the time being, I am just going to use the audio. So this slide, steps to obtaining a predicate order. I mentioned that I work at Chicago Volunteer Legal Services, and we do a lot of family law cases. We're a civil legal service provider, and I'm the director of the Guardian Ad Litem program for minors. So I deal exclusively with minor guardianship cases. And all of these cases, particularly for minors that are now 18 to 21, are going to fall under that realm of guardianship. And so as Hillary mentioned, this is a three-pronged process. And the first one is getting that predicate order from a state court, which is going to be a guardianship court in these situations. So the steps to obtaining a predicate order, as with any civil case, you're going to meet with your client to draft the necessary documents and file the petition. And then you will, if you're a pro bono attorney working with NIJC and or CVLS, we will talk to you about what type of service or notification is needed. We have the advantage that the Probate Act is less strict when it comes to notice to parents or to other parties, and that we don't need personal service in these cases. So that is a benefit to us on the pro bono side. We'll wait for our default date if necessary, or to serve the parents by publication. And then we will have a final hearing. Typically, if we have all of our ducks in a row, if we have documentation from the family, we have filed proper notification and sent notice to parents in the right way and waited the requisite amount of time. These cases often and hopefully only involve one court date, during which we appear in front of the judge with the minor and with the guardian, and we give the judge the relevant information, let her know what the situation is, and that should be it. Hopefully we can obtain that predicate order usually in one court date. So at least in guardianship cases, it tends to be a rather straightforward process and a good process for pro bono attorneys. Is this me also, Hillary? Okay, so the findings necessary for SIJS in that predicate order. So what are we looking for from that state court order? There are certain findings that are absolutely necessary for immigration purposes that really have to go in that predicate order. So some of you may have experience doing guardianship cases generally, and the courts tend to have their own form orders that they enter when they're granting a guardianship of a minor. For these cases, we're always going to use a draft order. The court is welcome to enter their form order in addition to this one if they wish to, but it's important that we draft our own predicate order with these specific findings, and CVLS and the NIJC will always help to look over all of those documents for you and make sure that you have the requisite findings in your draft order that you submit to the court. And this is what they are. So number one, the court needs to find that the child's reunification with one or both parents is not viable. Number two, that finding needs to be based on abuse, neglect, or abandonment, or a similar basis under state law. This must include a citation to the appropriate Illinois definition. And thanks to the NIJC's continuous advocacy, this now includes abandonment by the death of a parent, and that's clearly written into the state statute as well. And number three, it would not be in the child's best interest to return to her home country. So these are things that you're going to lay out in your petition and also state clearly in your draft order that gets submitted to the court.
So I'm going to jump back in just to give a very brief history of how we got to this point. So for those of you who were present for the celebration with the state representatives earlier this morning, they talked a little bit about a law that was passed, oh, it's not last year, it's like a million years ago, before the pandemic, 2019. Illinois passed another law updating state law to conform with federal law in order to ensure that all eligible children could access protection of SIJS. But just to show you a little bit about how we got to that point, SIJS itself was created in 1990 as part of the Immigration Act, but it looked very different at that time. At that time, what lawmakers realized was that there were children who were being left behind in terms of their legal status, and may have ended up in foster care due to abuse or neglect, or they may have ended up without a parent in the United States due to a wave of deportations that happened around that time of parents that left a lot of children alone and abandoned in the United States. Those kids were then often put into foster care, but then when they started aging out of foster care, their caseworkers realized they weren't eligible for any of the benefits and supports that are typically provided for kids who move forward to independence from the foster care system. So SIJS was created to ensure a path forward and some stability for those kids. And one of the requirements was that the children be determined eligible for long-term foster care, because it was initially imagined as just for that particular group of children. In response to that, 13 years later in 2003, Illinois created its own state law incorporating this language into our Juvenile Court Act, which governs the child welfare systems. And it included those requirements that the children be eligible for long-term foster care. But only a few years later, in 2008, the Trafficking Victims Protection Reauthorization Act actually fundamentally changed what SIJS looks like and created what we call the modern SIJS. It acknowledged that it is not just children in long-term foster care, but there are many children in very vulnerable situations who are deserving of this type of protection because they are victims of abuse or abandonment or neglect, and because it would still not be in their best interest to return to their home country. It also ensured that children would be eligible for SIJS even if they were harmed only by one parent, because there's still multiple situations in which that leaves a child very vulnerable, and the stability of being able to stay in the United States would be very important. So modern SIJS, to quickly review, removed the long-term foster care requirement, added the one parent eligibility requirement, and just clarified certain things about what the required language was. But what that meant was that Illinois' laws in the Juvenile Court Act in 2003 fundamentally mismatched from the federal laws, which resulted in a great deal of confusion because from 2008 until about 2019, the ability of advocates to go into court on behalf of a child, ask for these special findings, was really limited by the fact that if a judge was not familiar with SIJS and they looked to the only Illinois state law that referenced SIJS, it was incompatible with what the advocates were saying, right? The judge would look at the state law and say, well, this child is not in long-term foster care. What do you want me to do? And while some judges were able to be convinced by references to federal law and explaining how the federal law had changed, it was really, it was confusing, and it made the process much more difficult because there was not this state law to rely on. So 2019, the law that was signed updated the Illinois language to match the federal language. It removed the long-term foster care requirements. It updated the language to show that harm could be by one or both parents. And it incorporated the SIJS language into all laws governing all types of juvenile courts. Previously, SIJS was only under the Juvenile Court Act in Illinois, meaning that a judge looking at that could say, well, this case, for example, a custody case or an adoption case, does not fall under the Juvenile Court Act, therefore I have no jurisdiction to enter these findings. So 2019 updates the law, clarifies which courts have the authority to make the findings, but still leaves behind this small section of vulnerable youth who are eligible under federal law, but are not able to access the courts to get this protection from ages 18 to 21 in Illinois. So if you move to the next slide, we're going to talk about the law that we're celebrating today. This is effective as of August 6th, so it's effective now. This aligns Illinois law with federal law. It makes sure that 18 to 21-year-olds can access a court as a juvenile, still as a juvenile court. So we're not talking about adults with disabilities, guardianship, or any sort of diminished capacity here. We're talking about a court acting as a juvenile court in order to take jurisdiction to make those special findings. And in doing so, this is intended to provide some consistency in results across Illinois, because this is statewide. If you move forward, I will talk briefly about the actual language. So please look this up. If this is something you're interested in doing, please read the actual section. It's not that long, but this is really the meat of the amendments. And it's really important to understand what we're looking at and what we'll be working with when we bring these types of cases. So the key pieces are: minor is now amended to include an unmarried person who is under 21 years old. So that means 18 to 21, you are still considered a minor for this purpose. The court that is making the determinations over this person under 21 years old is considered to be acting as a juvenile court. So there's clarity here. We're not talking about any sort of adult guardianship or any sort of diminished capacity. We are talking about minors still. So what does someone need to do in order to file this type of case? As Rebecca mentioned earlier, these will all be brought as guardianship cases. This was the most streamlined and effective way to do it. So a petition for guardianship of a minor who is 18 years of age but not yet 21 years of age may be filed by a parent, relative, or non-relative person over the age of 21. So we've got two big changes here. One is an adult can file for guardianship over someone who is 18 to 21. Two is that petition for guardianship can be filed by a relative, a non-relative, or even a parent. So they'll be coming into probate court, filing these petitions asking for a guardianship that would last until the person is 21 years old, and then including those special findings of abuse, abandonment, neglect, and best interest. So some of the protections, and we'll talk about this a little bit more. I think Rebecca will talk a little bit more about the implications for the young people themselves. It's really important to note that this is with the consent of the minor. So this is not a situation where an adult can force a guardianship on someone who is 18 to 21 years old. The minor has to consent to this guardianship. The court can appoint the petitioner as the guardian of a minor in connection with a motion for special findings under this section. Also really important to note, we have not changed the age of majority in Illinois in a general fashion. This is specific to this section of the Probate Act, meaning if someone is seeking a 18 to 21-year-old guardianship under this section, which is the Special Immigrant Juvenile Status section, then they can bring this case. So it's limited in function. We're not changing the age of majority to 21. We are simply allowing this group of vulnerable young people to access the juvenile courts in a way that complies with federal law. So I'm going to turn it to Rebecca for what does this mean practically for Illinois youth?
Thanks, Hillary. Can you still hear me? Okay, I'm so sorry for these technology issues. This has never happened before and it was working just fine. Okay, so what does this mean for Illinois youth? As Hillary mentioned when we started, a minor for the purposes of this section means someone who's unmarried and under the age of 21, and like Hillary said, consents to the appointment or continuation of a guardianship. So either continuation of a guardianship beyond the age of 18 or entry of a guardianship after the age of 18. So this is something that is going to require the consent of the minor and can only be done if the minor agrees to this. Because like Hillary said, we are not extending, we are not changing the age of majority, and so this is something that they must agree to protect their best interests. And along with best interests, that's something that the court is always going to consider, particularly in a guardianship proceeding, and that includes factors such as the protection, well-being, and the care and custody of the minor. And they're also going to consider decisions regarding findings, orders, or referrals to support the health, safety, and welfare of a minor or to remedy the effects on a minor of abuse, neglect, abandonment, or similar circumstances. And so it also mentions referrals. So a minor who is the subject of a petition for guardianship, or in this case, an extension of guardianship under this subsection, can be referred for mental health services, educational, medical, and social services that may be deemed necessary. So in many instances, there are situations where young adults could benefit from referral to these types of services, and that will all be something that the court can take into consideration, and the court can refer through a more official process, which could also benefit the minors in question. Participation, again, in any referred services is going to be voluntary as well. And then as someone who practices in guardianship and is always looking at the best interests of the minor as a GAL, some of the questions that came to mind for me were, how is this going to affect minors or people who are between the ages of 18 to 21 since we are extending guardianship? And I think some of that is an unknown. I don't know exactly what types of issues might arise, but the spirit of this law is that this subsection does not authorize the guardian to abrogate certain rights of a person who has obtained the age of 18. So aside from not getting married, which would make the minor ineligible for SIJS anyway. So we would advise them that that would not be recommended in these situations. The assumption is, and the hope is, that this will not affect the other rights of anybody who has reached the age of 18. For example, the ability to vote, and certainly not to, and it states clearly, decisions regarding the minor's medical treatment without the minor's express consent. So the hope and expectation is that it will not affect the rights of young people who have reached majority outside of making them eligible for this important immigration relief.
All right, so I'm going to step in here and talk a little bit about what this means for attorneys. Anytime that we as attorneys are going in and talking and advocating about a new law, there's going to be some hiccups and challenges. And so I want to just preview that a little bit and talk about, ways that we can sort of get at that head on. So the first thing is always going to be important is that you have to remember you have to advocate to your client as well. In a lot of languages, the word guardianship is not going to explain what this is. In English, it barely explains what this is. So it's going to take a lot of time to make sure that your client actually understands what you're doing for them, that this is different from a normal guardianship in the ways that Rebecca explained. And we're also going to have to advocate to the judges, especially downstate. In Cook County, all of these cases are going to get assigned to the same judge. And so that judge is going to have a little bit more familiarity. We're going to be able to hopefully roll through these. But for those of us who practice in the collar counties or even downstate, those judges are not going to be as familiar with this. And so we're going to have to make sure that we're taking the judges through the statute, explaining that this is just making sure that we're harmonizing state law with federal law. They might not know about the change, so we might have to explain that this is a new law. It's just become effective. There might be prejudices and biases, despite the fact that I know that the Illinois court system is working really hard with judges to sort of erase that stuff. Some judges might think that the law is unjustified and say that this doesn't make any sense. If there's a guardianship, that means that this person must have some sort of diminished capacity if they're over 18, otherwise I can't grant the guardianship. And it's going to be our jobs as pro bono attorneys with NIJC's help. They're not going to like throw you in here and say, go figure it out yourself, right? But we're going to have to work together to make sure that we can explain that, no, this is what this law is. It makes perfect sense if you think about it from a harmonization between federal and state law perspective. So just as we go through these cases, it's going to be important not only to advocate for with your client and make sure that they understand what the rights and responsibilities between the guardian and the minor that's between 18 and 21 are, and also making sure that the judges are comfortable and understand what relief we're asking for, because in a lot of cases, especially the judges downstate, are mostly used to seeing those form orders that Rebecca talked about, and they're not going to be as familiar with a long draft order that we would be submitting. Hopefully we don't have to do that. I know Rebecca is working with the Illinois Supreme Court Commission to try to make sure that we can maybe get some forms with this, which would be awesome and make this a lot easier. But as we get to this, as we get to this kickoff point where we're starting to work on these cases, they might not be familiar with those longer orders. So that might just take a minute to explain as well. So this is just a little bit of background, a little bit more information in what I was talking about. There is this law, and Hillary is going to talk about this a little bit more too. This is not a new concept. This law is actually modeled on other states' laws that have survived judicial challenges, especially one in California. So, understanding and being able to explain that also to the judges is going to be really important as well. So keeping in mind that, this might be a little bit rough in the beginning as judges start to understand, these cases will probably go up on appeal, but that doesn't mean necessarily that you need to do an appeal or that you have to commit to doing that, right? I'm not trying to scare you, because these cases truly are rewarding and for the most part, very straightforward, like Rebecca was saying. But keeping in mind that it's going to be really important for us to make sure that we're following all the little procedural rules, that we're not getting tripped up by anything, and making good cases that can go up on appeal and then make good law. So I think it's important, like Hillary was saying, go read this. While we're figuring out how to get to the next slide, one of the things that I think is really great about volunteering in this program is there's so many different ways to be able to, and different cases to be able to help out with. I've done SIJS cases outside of the, I mean, not in the new context, but in allocation of parental rights, in divorce cases, in guardianships. It's a really great way to build that sort of expertise outside of the usual context, because most of these cases are uncontested. It's a really great way to have young associates get their feet wet as they move forward in becoming better volunteers.
Yeah, I would add to that. I think it's pretty significant to point out that most SIJS cases will be uncontested by their very nature. And that both, as Sarah said, makes them good for newer pro bono attorneys, because it's quite enough to figure out the procedural piece of this without also ending up in a protracted custody battle that most of us don't want to end up being in. But also that is what is best for the minor children. Sorry, I am a bit distracted. Okay, so I am going to pull up the slide on my screen so that we can go ahead and move it forward. Sarah, just so that you know, our next section that I'll be pulling up is going to be about how Illinois is leading the way.
So I'm going to preview this a little bit while Hillary's pulling this up. It's like I was mentioning previously, that this is not new. We've not reinvented the wheel here. We're working off of other states that have come up with really, I think, good statutes, well-written statutes that allow us to sort of then build and grow what they've done based on the case law that they have done as well. And I'll let Hillary explain a little bit more.
So, can you see my screen? I'm going to try to figure out how to
You're all good. You're all good, Hillary. We can just see the PowerPoint.
Okay, great. So what we have reached is how Illinois is leading the way. So this law was developed on existing laws from really only 5 other states throughout the country who have extended this type of protection to 18 to 21-year-olds. And it was created very specifically to mirror those laws because, as Sarah mentioned, the Cuccinelli lawsuit was a lawsuit that was brought challenging some of the laws in these states. USCIS was rejecting predicate orders, I believe, from California and New York and maybe one of the other states, saying that the 18 to 21 jurisdiction was invalid. There is now a settlement agreement and those laws stood. So we did draft as carefully as possible to try to make sure that this law would survive any legal challenge and would benefit our potential clients as much as possible. What we do anticipate, as Sarah mentioned, is that there may be some pushback based on the fact that we are essentially extending the concept of minor guardianship in this limited way to 21. We believe that we are doing this in a lawful and valid way. We are extending this guardianship simply to conform with federal law that defines youth under 21 as minors in the immigration statute. But we do want to work with the states that have already implemented some of these laws to anticipate some of the challenges that we might find and anticipate some of the best ways to bring these cases and to litigate these cases if necessary. And that's with the hope that we can serve as a model for other states. We really are interested in making sure that this protection is extended for vulnerable youth. You know, as you all know, there's no magic button at the age of 18 that suddenly turns on making you an adult. The children who are in this vulnerable position are frequently just as vulnerable up until the age of 21 as they are up until the age of 18. So we really depend on our pro bono community to help us both bring these cases, shape the way that this law is implemented, and to extend this relief to youth and young people throughout the state. We will be moving to questions shortly. I'm wondering if we could get everyone who is on to let us know if they have done a predicate order before and what challenges they may have seen in doing so. And I think we'll have that shortly.
Hey, Hillary,
ability
here's
to
a
answer
poll.
that question.
Here's a poll
Oh, there
that
we go.
yeah, there's a poll
Okay.
here. So have you filed a predicate order for an immigrant child? And the answers could be yes, not yet, or working on one now.
And while you're looking at that and responding, I'm going to turn it back over to Sarah to talk about what the pro bono community can do.
Great. Well, I'm really excited to see. Wow, look, that's great. I'm just looking at the poll results here. It's kind of exciting here. Some about half and half, yes, not yet, and some of you guys are working on one now. It's exciting. So let's talk a little bit about what pro bono attorneys can do. I mentioned this in the very beginning of what I was talking about, but these cases are so diverse. There are a lot of different contexts in which you can apply for SIJS. And I was mentioning this a little bit before, but this is a great way to get used to proceedings that are almost certainly going to be uncontested. But in order to make sure we do that in an effective and good way, and that you're setting good, using the best practices and stuff like that, we have a couple of suggestions. Number one, and I find this all the time with the SIJS cases that I do, is you got to explain. Because a lot of times these forms of relief are a little bit strange for people, especially if they come from a country that doesn't have an established rule of law, where these concepts are not going to be familiar. So you've got to keep explaining what you're doing. And I know that there's a big temptation when there's an uncontested case that you're the attorney, just check, do all this stuff. Make sure your client understands what you're doing. Make sure your client understands where your process is at. Make sure your client is making sure that what you're filing is correct, and that the details in there are correct. Because one of the worst things that can happen in an immigration case is you get contradictory paperwork. So you want to make sure that you're avoiding, to any extent that you can, any contradictions between what you're putting in your filing and what eventually is going to be in the SIJS filing. USCIS always looks for that kind of stuff, and it's an easy one to avoid by making sure that you're talking to your client, you're staying in touch with NIJC if something comes up that doesn't look the same as what came maybe in the original case file, those types of things. And then again, keep in touch with your client, who is the proposed guardian, and set expectations. They're going to want to know, like, how long is this going to take? If you haven't done one of these before, it's okay to say, you know what, we don't know. This is an county we haven't really worked in, but we're going to try our best to get that information, and we'll work as quickly as possible. Especially for a lot of these cases where the kids are about to age out, it's really going to be important to continue to push and not just like let things hang out on the calendar. Again, we talked about some barriers already, that, sometimes there are no words in that client's language that are going to actually accurately describe what's going on here. And so you got to work with a good translator. You got to work with a translator that's going to be able to explain sort of nuance here, to make sure everybody understands and is on the same page. And then, of course, we have judges that are going to be unfamiliar with this. That is a really great opportunity, especially as a young lawyer, to get in there and really talk to a judge. I think in some cases, especially, when you're a baby lawyer and we have a bunch of first years who are going to be starting or already starting at their firms and that are eager and excited to get into court and, and start litigating these cases once their bar admission comes through in 2 weeks or whatever it is, however much longer it's going to take. I'm not sure with the new, online bar exam, if it's going to be faster or not. But in any event, I know there's going to be a lot of people who are going to be eager to get in and cut their teeth. This is a really good opportunity to learn how to advocate with a judge and to say, look, I'm not here explaining or trying to tell you what to do, Your Honor. I want you to learn about this law. And so this is I think, a great opportunity to do that.
Hey, Sarah, before we move on to the next slide, let's launch one more poll here. And the question will be, what has been the most difficult? Oh, it was closed. That's my bad. But why don't you put it into the chat here because of technology again. What has been the most difficult part of filing predicate orders for an immigrant child for participants on the line? So drop it in the chat here because the poll is not working right. So working with the client, working with an interpreter, explaining the process to the judge or working with the judge, getting the magic language, or other. Drop it in the chat what your answer is. And we'd love to hear more about your experiences.
And I'll talk a little bit about mine while you guys are putting that information in the chat. I always find that working with a client it's not that it's difficult, it's not like that it's hard, but it's the most challenging thing, I think, because so much of this is uncontested. A lot of the judges, especially the ones that are familiar with SIJS, are very like, this is fine, like, let's just move along. I think that might change under the new law. We might have some different experiences and that kind of thing. But for the most part, I think making sure the client understands what we're doing, making sure that we're spending the time to explain and all that stuff is the most time-consuming part. Not that it's difficult, because it certainly can be done. And I use interpreters all the time, so that's not a problem for me. But I know that some of my junior associates that haven't worked with an interpreter before also find that a little bit challenging as they, get used to. You have to speak for a short time, let the translator translate, that kind of stuff. It takes a little bit of getting used to, but that's going to be the case with whatever type of case you're doing, not just an SIJS case.
Right. So we see, thanks, Sarah. That's insightful. We do have one comment here from Allison, and maybe Rebecca or Sarah can comment on this also. But so one difficulty has been doing court-related things as a corporate attorney.
This is my favorite question.
How are we working with corporate attorneys in Illinois state courts?
I'm happy to take that one, Rebecca, if you don't mind, because my firm is 95% transactional attorneys. I have almost no litigators at my firm. I'm a litigator by training, but almost everybody who helps me on these cases or takes an SIJS case is a corporate attorney. And the number one thing that I tell them is standing orders, standing orders, standing orders. There are instructions for almost everything, especially in Cook County, Lake Will, DuPage, even Kane. They have a lot of instructions. The other thing is CVLS has a lot of great resources, and NIJC has a lot of great resources. So you're not doing this on your own. I always think it's somewhat helpful for your first one. You can get a litigator to just look at your stuff and make sure that you're filing stuff and working with your litigation group, whether that's your docketing team or whoever does your filings at your firm, to make sure that they know how to do that kind of stuff. But what I often recommend doing is find a paralegal if you work at a firm that has a litigation paralegal that's willing to help you get stuff filed. And then use the materials. Most of the stuff is not things where you're reinventing the wheel. We've got really great support from NIJC, and they have great forms and samples that you can use. And then CVLS is always on hand and has been very helpful to me in procedural stuff where I'm not so familiar. So I've litigated in Lake County before, but I'd never done a divorce in Lake County before. So we had some questions about how that would work. And Rebecca and her team were able to answer that. So don't be afraid. If you're a corporate attorney and you want to do this, this is the best type of litigation to learn on, like I said, because it's uncontested, because there are so many good forms, and because there's so many good resources. There's a lot out there to help you make sure that you're not going to mess anything up. And worst comes to worst, you get another hearing, right? You blow, some sort of, you forget that you need to wait you have to get 3 successive filings and you file a default too early. No problem, doesn't matter. You can always continue it, reset the hearing. That's the thing about litigation, especially when it's uncontested, is there is a lot of that you can be, they can be forgiving about it. Not saying mess up on purpose, and there's no reason that you should, because there are such great resources, but it's not like, a misplaced comma is going to be as detrimental to you in one of these as it would be in a big, millions of dollar, financing for somebody. Can't hear you, Rebecca. I see you're trying to talk.
Can you hear me?
Yeah, we did it.
Okay, sorry for all the technology issues. I would agree with everything that Sarah says. I spend 99% of my time supervising corporate and transactional attorneys in guardianship court. That's my job, is to supervise pro bono attorneys, and the vast majority of the attorneys that work, at least in the guardianship program, are not litigators. Many are first-year associates, have never set foot in a courtroom. And I echo everything that Sarah said, that these are really ideal cases to get your feet wet, or to take on a pro bono case, again, because they are uncontested, and we do have so many materials for you and samples. And both the NIJC and CVLS are organizations that really provide step-by-step support on cases. We're not going to just give you this case and say, good luck, let us know when it's done. We are constantly talking to volunteers and answering questions and going to court with you if needed. So we are here to support you every step of the way, and you will not be reinventing the wheel on your own. I was cut out earlier by my camera, but I think particularly important, and Hillary mentioned this, for anyone who has experience in other counties, we have a lot of cases that we've done in Cook County, and there's only one judge who hears minor guardianships in Cook County. So she's very familiar with SIJS, and she's friendly to these cases, and we've had a lot of success in that courtroom. But it's a large state with many other venues. So if anyone has connections there or experience doing family law in other counties and other areas of the state, those are always in need. And we would be super grateful for your help on these cases in other areas.
And now you can do Zoom court. You don't have to go anywhere.
Right.
You can make a case in Whiteside County if you want, and you don't have to spend all the time in the car driving out there. The Illinois Supreme Court has made it very clear that Zoom hearings are not going away. So you can take one of these cases from your dining room in Chicago, if that's where you happen to be, and do these cases out in the collar counties or further away. And my personal experience, and I know Ellen, you have to we have to move along and stuff, but I just want to put one plug in for faraway counties. They are really grateful for pro bono attorneys out there. And if you tell them that you're doing this as a volunteer, they will help you. And they have really nice clerks that you can actually get a hold of on the phone, which is not always the case for courts nearby here. So please don't let that scare you. You don't have to travel. You don't have to do anything, that's that crazy. You might be, being a little bit of a maverick in that somebody might not have brought very many of these cases in, say, Whiteside County or something like that. But the judges are super grateful to have people do these pro bono cases.
Yeah, that's absolutely true. I have an intern doing a guardianship in Lake County right now. She has probably never set foot in Lake County, and she's going to be great. So you can do it.
And while we're plugging, I just want to point out, we again have the urgent cases on our list. Our most urgent need right now is for a case that's in Peoria. I promise I will be there with you every step of the way, but we need a great deal of assistance in some of our urgent pro bono cases. But we are happy to provide the support and templates throughout the process.
And I think this is a great segue because we actually have a poll right now asking where people have filed. We recognize that there's a lot of people on this call with different experiences. So I'm going to launch this poll and ask, where have you filed a predicate order for an immigrant child in Illinois? Is it in Cook County, in Northern Illinois, in Central Illinois, in Southern Illinois? The boundaries are relative. Where have you been in this beautiful state, and where are you practicing? Where do you have this experience? We'll give a few seconds here for people to click on that response, to click their responses. I understand that you can probably only click on one. So it's an imperfect poll, but it's fun to see where people are these days and where Zoom has allowed us to go. And two, a big thanks to our partners that are in Southern and Central Illinois and bringing this law, from tip to tip of our long state. So I'm going to close the poll here in 3, 2, 1, and we will see the results. And the results show that we are 50-50 in Northern and Central Illinois. So I would assume Northern can include Cook County as well. I understand why you might have made that choice, so thank you. So that's really great to know, and we are reaching out to partners in Southern Illinois as well as we move this extension of the law forward and can protect immigrant children across the board. So with that, I also wanted to say, Erica, I know that you had raised your hand and unmuting is difficult in this scenario, but if Erica or if anybody else has other questions or comments about, how are they getting the magic language? How are you what difficulties have we had or workarounds working with interpreters. We can definitely respond to that in the chat, and our panelists are available to respond to that. So while people are typing in their questions, Sarah, excuse me, will take it to this next slide.
All right, so like I was saying before, this is a great time to start doing this work. What we have right now, what NIJC, it's like NIJC is mine. I feel like that because I'm so grateful for them, and I'm so happy to be part of their team. NIJC has a lot of cases that need to be cleared out. Right now, what they're placing are cases under the old statute. So these are ones that need to be cleared out, and the backlog needs to be filled so that we can focus so the people who are a little bit more experienced in this and people who are in-house at NIJC can focus on those new cases and make some good templates and get some good information and all that stuff on the new cases. But we can't work on the new cases if the old cases can't get placed. So here I'm asking you, take a look. There's a case list. It's in the handouts. If you go into the handouts here, we're also going to circulate it. You can also find it on NIJC's website. You can also email Hillary or email Ellen or anybody at NIJC, and they will make sure you get that case list. I will send you the case list if you feel more comfortable getting it from me. There is a huge need right now, and because we have cases where people are about to age out, and we know that we can do their cases under the old statute, we want to try to do that for there to be less uncertainty for these people. They're already in very vulnerable and uncertain situations. We don't want to be doing things different way if we don't have to, right? These trainings are on demand. You can watch it anytime. There's a really great training that Hillary and Rebecca did. You can watch, get all the nuts and bolts, get everything you need. The resources are all super great. Hillary will email them to you when you take a case. You'll have them. You can ask whatever questions you want. The whole team gets CC'd whenever they place a case. So you've got a couple of folks at NIJC. You've got Rebecca. And there are, like I said, tons of resources. If you're at a big firm and you have a pro bono counsel at your firm, talk to your pro bono counsel. I can almost guarantee you that if you're at one of the big firms in Chicago, there's somebody else who's done one of these cases. So you can even talk to people at your own firm as a resource to make sure that you're getting everything that you need done. But you can always go back to these checklists and samples and all this great material that NIJC has spent a lot of time putting together, and CBLS has spent a lot of time putting together to make sure that you feel comfortable, so that when you do have to go to your hearing and you sign on to your Zoom, wherever in the state you are, you know exactly what you need to do, exactly what to explain to the judge, and you can be successful in taking one of these cases and helping somebody who's really, really in need.
Thank you, Sarah. I could not have imagined a better plug. We really appreciate all of the work you've put into this and all of the cheerleading as well, both for us and for the kids and families that we represent. I'm not seeing more questions. I'm wondering if anyone has questions or ideas about what they think might be a challenge under this 18 to 21 law that we will be working under going forward.
And of course, if you don't have questions now, or you're trying to get ready for your 10:45 or 11 o'clock next meeting, you have all of our contact information. You can certainly feel free to, I can speak for myself, and I know that based on how many times I've emailed Hillary and Rebecca that they're also willing to answer any of your questions. We're here, even if I'm not at your firm, even if I'm not your pro bono counsel, you are welcome to send me any questions, any details about my experience. I'm happy to jump on a call and explain what doing one of these is actually like from soup to nuts, and refer you to some actual experts to talk about substantive questions if that's something that you need. But I think it's great to have you. I see questions come in from Jamie. I feel like I have to use templates from NYRCA when preparing my IL case. So when you say templates, Jamie, are you talking about for the court forms or your filings or you're worried that for the new cases you want to use templates from New York or CA, California.
And I think just so folks know, as Sarah mentioned previously, we are working on developing those new templates that reflect the language of the Illinois law specifically. But when we are in Illinois state courts, we do want to make sure we are citing Illinois law. I would also say if you're working on a case, feel free to peruse NIJC's website. We have a number of samples up there, particularly with the magic language itself, right? The standard custody and guardianship templates tend to look pretty similar across counties and state lines. It is the very specific SIJS findings that are less forgiving and so need to be much more specific once they are entered.
Yes, and Hillary alluded to this, but Illinois is in the process of drafting uniform guardianship forms for the entire state. I'm sitting on that form committee. It's an excruciatingly long process to go through every single form used in minor guardianship cases and work on them and make them proper and send them out for public comment, et cetera. But this is very timely. Hillary and I are hoping that we can incorporate these SIJ, like a template order that can be included in that suite for use throughout the state, maybe sometime in the next year. So we are actively working on that, and that would go, I think, a long way toward judge education and disseminating information throughout the state about this new age of majority.
Definitely. And Jamie, I'd just point you again, if you're having any trouble or feeling like you're needing to reinvent the wheel by, taking forms from other states, come back and talk to the folks at NIJC. There are a lot of forms that they have already that you don't have to worry about, and hopefully you won't have to worry about when we get through to the new stuff. But rest assured that even if you take one of these new cases, in the future when NIJC starts giving them out, this is not something where you're going to have to reinvent the wheel. It's going to be the best kind of pleading drafting, which is almost more like corporate attorney drafting, which I affectionately call Mad Libs. So you can, it's very easy. It's when I say that I'm obviously I'm joking, and it is difficult, and you need to make sure that you're being careful and that kind of stuff. But really, it's almost like a plug and chug form. It's just a little bit different because it's not an official court form. But really want you to know that this is not going to be a difficult thing, and I appreciate you raising it so that we can remind everybody about the great resources that are available, so that you don't have to worry about this taking a lot of time or being really difficult. As a litigator, one of my favorite things is drafting stuff from scratch. But when I don't have to do that, and I can use somebody else's work to be able to do 5 of those in the time it would take me to do 1, it's definitely worth taking advantage of those samples. And then making sure that you don't miss anything, because like I was saying, USCIS and Hillary was saying, USCIS is very picky about what needs to be in these orders, and so we need to be really careful in making sure that what we're doing actually is helpful rather than hurtful.
I would also point out that we are preparing cases now to bring under this new law. We are trying to be very judicious about the types of cases that we're bringing to start out with. It is an ambitious change in this legislation. It's really important, and we are excited to roll it out throughout Illinois to make sure that everyone eligible has access to this relief. But because of the challenges, the anticipated challenges that Sarah mentioned, the first cases that we're bringing, we're trying to be particularly careful about and make sure that they are worked up perfectly and that we have our arguments prepared, just to roll this out in an effective and an efficient way, and develop those templates for attorneys across the state to use. So if you do have a case that you're planning to bring under the 18 to 21 statute, for sure, reach out to us if you have questions, but also just give us a heads up if you do encounter hiccups or challenges, because we want to try to coordinate the implementation of this new law as best as possible to serve everyone. So yeah, I think I'm still just saying, please reach out to NIJC. We have the need, we have the templates, and we'd be happy to talk to you about your cases. I also want to plug, so we are nearing the end of our presentation. If we don't have more questions, we do have an evaluation that we'd like you to fill out. Please do that, particularly if you're looking for CLE credit. And as we've been saying, please check out our pro bono case list. Oh, and I am going to advance the slide. There we go. So this is the QR code for our evaluation. We welcome your feedback as always.
Takes 2 seconds. Just pop in, do it on your phone. Very easy. And I love hearing what people have to say. Hopefully it's nice stuff.
We do have one more question, it appears. And
Retired. Okay. Yeah.
So we have one question, and it says that, you know, for folks that are lawyers and have retired from large law firms, you know, not having that staff support, not having the large law firm support that you might have been used to, and then navigating this electronic filing systems in Cook counties and Collier counties, would there be any practical advice for how to do this? You know, and I think this also relates to like solo practitioners or small firm folks that might not have the support in general. And what are some ways that you guys have found to be able to maneuver the logistics?
I can take that one. So yes, the e-filing system in Cook County, where I practice, is definitely not intuitive at all. And we know that it can be difficult in Collier counties as well. We are at CVLS, we are not as adept at the Collier counties. We don't have as much experience doing those, but we do have some, depending on where they are. But especially in Cook County, we have, we're very accustomed to this because everything we file has to be e-filed in Cook County. So we have manuals and step-by-step instructions on how to file something, at least for Cook County. And since we are in the business of volunteer support, if a volunteer is struggling with that, we just file it in-house because we have our own attorney number, and we're accustomed to doing that, and when we know that is challenging sometimes. So you can always reach out to us with any problems you have, or if need be, just ask us to do it for you if it's a CVLS case.
And I'll put a plug also for the downstate counties. If you're familiar with Illinois Legal Aid Online, they have a step-by-step guide on how to do e-filing throughout the entire state. It's designed for people who are pro se, which hopefully means that it's easy and straightforward enough for anybody, regardless of whether they're an attorney or not, to file. So at least there they have some step-by-step instructions you can follow. And you can just Google that, and it will pop right up, e-filing instructions, Illinois Legal Aid Online. It's a great resource to help with e-filing, and in the event that you're not doing a CVLS case or you're not in Cook County. But I'll say I don't e-file my own stuff. I don't want to do it. My paralegal does it for me. I'm so spoiled. So mad props to anybody who is a solo practitioner or is, you know, getting accustomed to not having staff anymore, because it's one of the things that I rely incredibly heavy on as a big firm attorney.
Okay, well, thank you so much, everyone, for your time and attendance and your patience as we work through some technical issues on this training. But we are really excited, as we've been saying, about the rollout of this law. We are here for you, as we've been saying, for questions and concerns you may have. We are also waiting for you with open arms to welcome you into our pro bono community, so that you can take some of our urgent cases to help some of our most vulnerable young people. So we really appreciate your time. Please don't forget to take the evaluation survey, click on that QR code to get to it. And yeah, I think from here we'll wrap it up. Our emails are in this presentation and in the materials, and you can reach out to any of us with questions. So thanks all for your time.
Thank you.